Well, welcome back to Module 16 of the Series 65-66 review class, presented by Series 7 Specialists. We're glad to have you, and we're especially glad on this module that it looks like we're going to be able to get through the law part of it and get to something that at least is a little bit halfway interesting. I hate it that the material is so dry and boring and you have to do this, but those are the cards we're dealt. I mean, that's what they test on, and that's our goal, is to pass the test. So in any event, hopefully we'll be clearing up or finishing up rather the Uniform Securities Act part of the material on this module and going into the investment products. So anyway, do let us know, series7specialist.com. There's a contact us page there, and let us know if you have any observations or anything that you think would be of interest to us or with other folks that we deal with. So anyway, appreciate that. Let's go ahead and pick back up. We were on page 25 up towards the top, and we need to look at civil liabilities for violation of the Uniform Securities Act. Now remember, a civil liability, that's the administrator has no civil authority because the administrator was not harmed, injured in any way by the fact that someone stole money essentially from someone else. It was the person who was defrauded, and that typically is going to be the buyer of a security, and not just fraud. If there's just a violation of the law, if there's a misrepresentation, something like that, then the buyer may look to the seller. The seller may be liable for civil penalties. So what are those civil penalties? And basically the civil penalties, the seller can sue if there's been, just what we said, a violation of the Act, untrue or misleading statements, material omissions, and this is one place where remember to read your questions carefully. I mean, I keep going back and back and back to that. That's because I cannot emphasize that too much. Many times, so many times, you can't number them. There's one word that turns the question this way instead of that way. And just it'll open it up for you if you look for that one word. So be very careful to read these things, okay? A material omission, yeah, that's going to be a violation. An omission of any fact, but you can't say every fact. I mean, the fact that these people, they changed their letterhead a year and a half ago. Who really cares? It's not material. It's not going to change your mind. But material facts are different. They're going to influence you as to whether to buy, sell, hold. All right, so then the buyer can sue for what? Well, the original principle, I want my money back. How much money did they put in? That's what they can sue for, and that's the baseline of what we've got. But then, there are other things. That money could have been out at interest at the state's legal or statutory rate. I have no idea what that is because it's going to vary from state to state. But obviously then it can't be tested because it is going to, number one, it's going to vary from state to state. Number two, it's going to vary with market conditions. So whatever the state's statutory interest rate is, that's what the buyer can expect to get from the seller, less any income received on the investment. So here's the deal, okay? Bob, he sells some stock to someone, and they put $10,000 in, okay? As it turns out, it's an unregistered, non-exempt security, okay? And it was brought to market, or it was sold in a solicited transaction. Well, that's a violation right there, okay? And so the buyer can actually sue Bob or his broker-dealer or the issuer if we're still talking like Bob's dry cleaner and Bob sells the stuff himself, okay? But in any event, they can get their $10,000 back, all right? So they go to court, say, look, yes, so there was in fact a violation. The judge says, how much money did you put in? $10,000. Okay, that's it, $10,000. So wait. Yeah? So I could have had it out at interest. The judge says, okay, that's another $300. So $10,300. Bob says, hey, wait. We paid him dividends on that of $500. Oh, really? Yes. Well, let's see, 10,300 minus 5, $9,800. And then the buyer says, wait. He says, I can't just come here for free. I got to hire this guy, my attorney, and he ain't cheap. And besides that, he's got all kinds of costs for filing stuff and getting us to this point right here. judge says you got a good point. Okay? We'll give you your original principal plus interest at the state's legal rate minus that income that you received plus attorney fees and court costs. Everybody happy? Well, nobody's happy, but that's it. That's my judgment. All right, so anyway, that's the civil liability that the seller can face, what the buyer can sue for. But now the buyer cannot sue, it says, if an offer of rescission is made by the seller first. Now, if I'm the seller and I get some papers that say, hey, look, you've been served, show up in court, let's see, they might have taken that to the administrator because of that consent to service of process. Remember that? Okay, good. And so anyway, if I get those papers, it's too late. I got to go to court. But let's say that I realize I just sold an unregistered non-exempt security, solicited the darn thing. I go into my office manager, my compliance officer, I say, look, I just broke the Uniform Securities Act. I didn't realize at the time, whatever, but I broke the act. What can we do to make it right? Okay? Well, yeah, that's an important term. Can you ever do anything to make that act legal? No. It's a violation. Okay? Period. That's it. There's no question about it. It's a violation. The only thing you can hope for is to make it right. So how do we make it right? Well, let's see. We could wait around for the guy to sue us, or what we could do is that we could basically roll over on his front porch and say, you got me here. And so that's what we do. We prepare a written letter, a written offer, and we say, we'll give you your money back, your original principal. That's what the judge would have done. We'll give you interest at the state's statutory or legal rate. That's what the judge would have done. And by the way, you did get $500 of income from that dividend. They're going to deduct that out. Well, since they would deduct it, that's what we'll do. But you know the difference between the two? You don't have to go to court. You don't have to hire an attorney. You don't have to do anything like this because we're coming to you and we're saying we done wrong. You know, in fact, this letter that has all the details in it, if it were able to go to court, basically what you could do would be to stand up and read that information, and the judge would say, look, Dan, you don't have a leg to stand on. I mean, the information you gave your customer, it basically says you did it. You got a civil liability. So we're just rolling over here on, we don't want to wait till the courthouse steps. We're going to do it on your front porch steps. So no attorney, no court costs. Okay? And so there are a couple of things that the guy can do. The guy can say, yeah, he says, I want my money, so, make me whole. And that's it. And then the thing's done. It's over with. Or he could say, I want to think about it. I want to think about it a little bit. So, well, okay, let's see. What we'll do, we'll give you this thing, but the offer must remain open for 30 days. You have a month to decide. Okay? You snooze, you lose. Because if you don't accept it within 30 days, we've done all we can to make it right, we tell the customer. So, if you haven't done anything within 30 days, you've lost your chance to sue us because we tried. Okay? Or the guy can say, wait a minute, what stock is this? He says, well, it's Bob's Dry Cleaners. He says, you know what, I've been their customer for 5 years. I go down there and I know Bob personally. Once a month he shows me his books. Do you know what kind of economies of scale he's been getting since he opened up those other 4 stores? He's already paid me a dividend of $500 for crying out loud. Do you think I want my money back? How crazy do you think I am? Your choice, buddy. Your choice. But here's this offer. We'll still leave it open for 30 days. But once that 30 days is passed, you've lost your chance to sue. It's your baby then. Okay? So he doesn't have to do anything, but if he does, do it within the 30 days. That's an offer of rescission. Has to be in writing. Okay? Gives everything except the legal fees, court costs. Has to be open for 30 days. Statute of limitation on civil actions. Okay, now we talked about criminal, like FRAUD is 5 years. Okay, but this is civil action. Well, 3 and 2 equals 5, but that's not really a good way to remember it. Okay, what we have, let's just draw ourselves a little timeline. we actually count the statute of limitations starting from the date of the action. So the date of the sale starts the clock on the statute of limitations. So here's when the deed was done. The sale took place right there. Or other violation. It doesn't necessarily have to be a sale. All right, there could be other violation. But so I'll just put act or sale. Okay? And what that does is the minute that we do it, it starts a 3-year statute of limitations. And if we don't take any action by the 3 years, then if the person who's been harmed doesn't take action by then they've lost their opportunity to file suit. All right? We need to draw a little marker in here about 1/3 of the way down because this is 1 year. Okay? Let's say that the customer discovers that they have been wronged, that there's been something that someone would have a civil liability for in that first year. What it does is that it actually, come down here, if the discovery is right there, then that starts a 2-year statute of limitations. Okay? But if they discover that there was an action that violated the law right here, so there's our discovery point, then what happens is that we hit that 3-year statute of limitations first, so it only runs, that could be a month, don't know. All right? So it's the earlier of 3 years from discovery, 3 years from the action, or 2 years from discovery. So like I say, that's one way to look at it, where you kind of have it on a timeline out. Okay, so that's civil liability, statute of limitation on those, 5 years for fraud. Judicial reviews, when the administrator takes an action. Basically, let's just say he shuts down a broker-dealer because they're misdealing with their customers. Well, then within 60 days, there can be a review in the courts, in a court of competent jurisdiction, to basically rule on that action of the administrator. Now, if the administrator is simply making an investigation, you don't need that because we don't know how that investigation is going to turn out. It could be that someone gave a report to the administrator that was just all sour grapes. Okay? And the administrator got to looking and there's nothing wrong at all. Well, there's not going to be any legal action then. Okay, it's just we all did our job and let's just go on from here. But in any event, within 60 days of that action, like a stop order, cease and desist order from the administrator, okay, whoever had the action taken against them can appeal to the court of competent jurisdiction. Now, the fact that they appeal does not, what they call, stay that order. So basically, you just have 2 or 3 possibilities, okay? The first is the administrator takes an action, says cease and desist. And so we say, well, okay, look, I'm going to appeal that. So we file an appeal. The party who has to cease and desist files an appeal. The judge can say, no, I'm not even going to hear your appeal because you have no grounds to appeal it. I don't know what that would be. I'm not an attorney. Okay? The ruling still stands. The second, which is going to be more common, is going to be that the judge says, yes, I'll hear that appeal because that's what we're here for, and I see where you have some grounds to appeal. But the cease order, the cease and desist order, is still going to be in place because just because I'm going to hear your appeal doesn't mean that we can reverse what the administrator said. The third situation is where the judge says, number 1, I will hear your appeal. Number 2, I'm going to set aside the action that the administrator has taken, or I'm going to stay that order from the administrator. That specific action is the only thing that's going to set that order aside and make it of no effect. So if the judge doesn't address it, it's still in effect. 60 days to appeal, and like I say, it's stayed only if the judge specifically sets it aside. And the administrator's jurisdiction. The offer or acceptance is the key. Where was the offer accepted? that administrator, if there are multiple states that have jurisdiction, that administrator is the one most likely to act. So where did the action actually take place? That's the one most likely to act, although others can have jurisdiction. Then also, where was the offer directed out of? Where was the offer directed into? And you'll see examples where there was a broker-dealer in Iowa that had a customer that was in North Carolina. They, however, met in Las Vegas and did the deed there. Okay? So which administrators have jurisdiction? Well, Iowa does because the offer was directed out of there. North Carolina does because it was directed in there. And Nevada does because that's where the sale took place. Confirmation. The confirmation of the trade was mailed out of Michigan. Now, Michigan doesn't have anything. Okay, that's just where their mailing center is. And likewise, the guy on his way from North Carolina back to Iowa, back home to Iowa, he stopped over in Kentucky and mailed the check. That doesn't make any difference. It's a post office, for crying out loud. Who cares where it is? All right. So anyway, like I say, where it's directed out of, where it's directed into, or where the action actually took place. Where's the buyer a resident? That's going to be another one. But states which checks, certificates are mailed from, it's there to throw you off. So just like I say, there's no jurisdiction there. And let's see, we have publications or broadcasts. They're considered to be actions in the originating state, and publications with 2/3 of their readership outside the state is not considered to be in state. All right, so just do that. And then also with the broadcasts, you've got broadcast in and listened to or watched this state, some other state. Okay, so you have a little matrix. What you want to look for is, because that gives you 4 really easy answers, is a broadcast that occurred in this state and was heard in this state or watched in this state. That's one where the administrator will have jurisdiction. All right, so anyway, finally, state-specific considerations concerning the internet. An internet site is not considered to be an action in a state if you do everything you can to say, look, we can't control where the internet goes. All right, that's the bottom line on all those subpoints. Look, the site contains general information only. There are no recommendations. Well, then, if there are no recommendations, then what, like I said, there's no action that you can take. If there's a clear disclosure that the person may only conduct business in states in which she or he is registered. So, I put on my website, I'm only registered in Oklahoma, Texas, Arkansas, Kansas, and Indiana. If you're from some state other than that, I can't do business with you. Then I can't prohibit people from finding me, but I can tell them, no, I'm not even wanting to talk to you, so I'm not soliciting you. And so that's not going to be an in-state action. Or if there's an exemption, of course, in that state. Agents and investment advisor reps must disclose their principal firms so that you're not just someone out there doing something on your own. Firms must properly supervise the content of the site. If your firm allows for an individual page, you know how tight they are on that. So, like I say, just makes sense that that if I'm not trying to get underneath or around the law by use of an internet which can be accessed from Timbuktu, then there are certain situations where I'm not considered to be violating the law. Okay, I'll tell you what. I thought maybe we would get our feet wet in investment vehicles, but really it's getting close to time to wrap up this little module. In fact, we'll probably wrap it up just a couple minutes early, but that's fine. What makes a good breaking point? One of the things that I want you to do, okay, is first of all to read your questions carefully. Start on your practice exam questions. Look at why you missed what you missed. What do you mean? Well, I mean, is it something that I just didn't know it? Well, that's easy. I just review that part of the material. Is it something where I mixed up investment advisors and broker-dealers and got the one and the other? Well, that's really pretty easy. Number one, read the questions more carefully and see which one they're referring to. And number two, become familiar with which is what. I mean, the prohibited practices. That table we talked about that's in your textbook, that lines out the laws for investment advisors and broker-dealers, state and federal regulations as well. It's another thing to look at. Okay? Did I miss a word? Did I miss that not? Did I miss that only? Did I miss that every? Did I miss that except? You'll do it. And every question on this test is precious. Okay? So discipline yourself to, I recommend that once you get finished, you just take like 2 seconds to, okay, I'm going to clear my mind. I've got my answer. It's fine. I'm not going to question my answer. I'm going to go back up. I'm going to reread that question just to make sure that I saw all of those key words like except, not, only, must, okay, that are either very exclusionary or very inclusive, or that take someone going this way and turn it right back around the other way. Okay? I'm going to make sure I've seen that. I'm just going to, big picture, I'm going to get the general idea of what they're talking about. I'm going to differentiate state, federal. I'm going to differentiate investment advisor, broker, dealer. Okay? That question the question. Okay? And if you find that you approached it wrong, then's when you start to question your answer. Okay? But like I say, it's just a good idea to see why you missed, what you missed, so that you can take corrective action. All right? Read those questions carefully. You really have to. Well, I'll tell you what, we've wrapped up with law. We'll go ahead and break on this module, and then we'll come back with module 17 and start on the investment vehicles. We'll see you in a little bit.